Thank you, counsel. I appreciate your patience. You may be seated. We are here for oral argument in our case CV24-0101, Riley versus Tolmachoff. I'm sorry. I am Judge Ferruia. To my right is Judge Morse. To my left is Judge Weinsweig. And as you may know, we record and live stream these proceedings, so please give your name and the name of your client prior to your presentation. You have a maximum of 20 minutes per side, although you are not required to use all of that time. We do require you to keep track of your own time, and the clocks on the podium are there for that purpose. They do include all time remaining for your side, including any time that you may reserve, which you are required to keep track of yourself. Please keep in mind we have read the briefing and studied the record and discussed this case in conference already. Also, to any who are visiting and observing these proceedings, we remind you to put your phones on silence to avoid any embarrassment. With that, counsel, you may proceed.
May it please the court. Ray Dietrich for Chad Riley. I'd like to start off, if I may, by reading 10 U.S.C. 1408 C3. This section does not authorize any court to order a member to apply for retirement or retire at a particular time in order to effectuate any payment under this section. And that's what the Barron Court used along with its interpretation of how in denying direct Kelch payments. So it's certainly not a textual reading of that statute, because there's nothing in there that talks about direct payments. It talks about an application for retirement or to retire at a particular time. So it's implied that the Barron Court went beyond the text and perhaps looked at the purpose of that statute. I couldn't find any.
So, counsel, let me make clear. Your argument is not premised on the plain language of the text. It's premised upon a decisional law from the state of Arizona interpreting this more broadly.
That's true.
Would you concede that you lose under the plain language?
No, because we would do that in combination with how, which is what I was going to go to. So Barron based their decision on prohibiting direct payments on this statute as rationale, but also how.
Right. I mean, again, you started with the statute. I want to focus just on the statute, USC 1408 C3. Just on those words, I guess the question for you would be, did the court order a member to apply for retirement or to retire at a particular time? Did the court do either of those things?
On a textual reading, the answer would be no. They didn't order that.
Okay, but then I understand now. Let's talk about the two cases that have interpreted.
Okay, and that's a fair point. They justified the prohibition about direct payments, that statute and how. But if you recall, how involved disability. So it has nothing to do with direct Kelch payments. And what the court said in Barron, again, going beyond a specific issue, the Barron court said, and I quote, direct payments is no different in principle, and I think that's the highlighted term. Direct payments is no different in principle from the equitable remedy how disapproved. And I think we can apply both 1408 C3, because we're dealing with the underlying benefit of a military retired pay benefit accrued during the marriage. And what we're probably going to have to do eventually, in some form, move that benefit from the military over into the federal system. So to me...
Counsel, help me, just so I understand, because maybe I'm thinking of things too simplistically, and this is your opportunity to tell me that I'm not. You don't dispute that half of that military time was wife's.
Don't dispute it. Yes, sir.
Okay. And so husband leaves the military and then begins working for the federal government, and he decides to take his half and put it in the FERS.
He has not done that yet, so that's not true.
All right, he hasn't done it, but he can.
Absolutely. It's called a deposit.
Okay. And your dispute is that even though he can do it, he is under no obligation to do it for wife?
No, not at all. He's no obligation to do it at the court or the former wife's demand. And we're getting back to...
Well, I guess that begs the question what an obligation means, but she can insist him to do it.
Repeat that, sir?
She can't insist that he do it.
That's right. Not this time.
And what harm is there to husband in doing it?
He would also have to deposit his time, and it's a total amount of money, about $17,000, and he would have to either finance his half, or he can make payments through DFAS.
Counsel, does the system
roll it directly from one plan to the other?
No, he has to deposit it. He has to buy that time. So her share is about $7,000, and his share is the balance of the 17.
But if the money remains in the military pension, what is it worth to wife?
It's not worth anything.
It's worthless.
It's a contingent interest, just like her interest is FERS.
What about to your client? If he doesn't roll it over into FERS?
It's not worth anything.
Okay, so as an economic calculus, it's $6,000 to pay to roll over versus getting no retirement benefits.
Well, $6,000 plus his share that he would also have to deposit.
I'm talking about his share, yeah.
Yeah, it would be both. So
wife was ordered to pay her share, right?
That's right. She initially pled that Chad Riley would to pay that, so they changed that. So that's how she initially pled the case.
Right, but the ultimate order was that she pay for her
That's
own.
right, her share.
And she tendered that, did she not?
She did.
Okay, and it was refused.
It was, yeah.
All right.
Because under this principle of Barron, that because the implied decision, the holding of Barron, is we're not going to be forcing military members to retire, to direct pay, and do things at the whim of the court or the client, the former wife.
Counsel, you said that he would have to roll over his time too, but did I not read in this record that that time actually can be moved over incrementally?
He can. He can do it deposits.
So it doesn't have to be all at once.
It doesn't have to be a lump sum. That's correct.
Okay. So he could, if he wanted to, hypothetically, move half of it into FERS and leave the rest of it in military retirement until such time as he wanted to move the rest over. Is that accurate?
I don't believe so. You have to either move the whole thing in, and then the agent of the government will work out the details with you whether or not you want to give them a lump sum for that or go on a payment plan. So it's an all or nothing, as far as I understand, an all or nothing proposition with the military.
Okay.
So he can't do payments.
So he can't move it over. So I'm confused now because you just said that they could move it over incrementally.
Meaning that he can move it over then make payments on that sum.
So he move it all at once, but then pay for it incrementally.
That's correct. Yes, I stand corrected.
Oh, okay. So, and you can work out like what those payments are, correct?
That's correct.
Okay, so hypothetically speaking, he could move it over and then he could use wife's money to pay incrementally those payments, and that would defer any
Well, he would more than likely take that $6,000 from the wife's and go ahead and put that in as part of the whole package to deposit that amount over into FERS. I mean, he wouldn't actually be using hers. That would go into that, and then the balance he would have to make the payments on if he didn't come up with a lump sum to pay it off.
But the point is that he could structure it how he wished.
He could.
Hypothetically.
He could. And the problem, though, with the FERS is he's not even vested. So I think this whole action is premature. You're vested at 5 years. He's under 5. So his interest and hers, whatever that is on the apportionment side, is contingent on FERS also. And he's a young person.
That's an interesting question because what you're doing with rolling over FERS is you're buying time, right?
Right.
Does that count to your vesting?
That I can't answer off the top of my head.
Because
you would think it would, but yeah.
It seems to me that you have
but I'm not sure.
11.7 years, that's not even all of it, right? That's just what was under the community's control. 11.7 years of buy-in time, if that translated, then that would...
That I can't answer that.
Okay.
Yeah, that I can't answer. But Barron also talked about that we have to consider the financial consequences of what's going on, and that direct payment is causing a lot of hardship in different cases with police officers, et cetera. So the financial consequences should be factored in, but again, he's not even vested in FERS. It's a contingent interest.
Okay. In terms of financial consequences, who's responsible for weighing that?
Well, he would on his part. So she's tendered that $6,000 and some change. He would have to do the balance. So he'd either have to come up with that through a lump sum or go into some kind of a payment plan with that agent, the governmental agent.
And is that part of what is subject to our review about whether or not that financial impact is reasonable, or is that something that's subject to the court's abuse of discretion?
Well, it'd be ultimately to the court for the discretion, but Barron said we have to consider the financial consequences. That wasn't, I don't think that's on the record completely on what her share of military is, what his share of the deposit would be.
Fair enough. Can you tell me where the evidence is that the court did not consider that impact?
I don't see it in their ruling. Mm-hmm. As well as I pointed out that they also didn't even consider the reserve option for Chad. And at that time of that hearing, it was on the table that he was and had applied for reserve.
But he's not eligible to serve.
That's right. And that came out, though, post-ruling. But that wasn't even broached by the trial court about his reserve option. If he would have got reserve, her share would have just come on over into the reserve function. But he had a disability that he can't go Marine Reserve.
Okay, so why are we talking about that?
You say, where is it in the record? So to answer your question, I don't see anywhere in the record that they did not consider financial or addressed it. So that was just an additional overlook to me by the trial court.
So help me understand, and maybe just he doesn't have the money, but why is your client opposing this? Why doesn't he want to roll it over and get the benefit of his military time in FERS?
He will at his timing, especially after he vests with FERS. So this is a new job. He's not ready to come up with that money now or go on to some kind of payment plan. It was forced upon him. And again, we're getting back to Barron, to the rationale of the holding of, I think, the purpose of the statute and what Howell says you can't do as inequitable remedies.
But let me ask you a quick question on that. I think Barron involved and Kolsch a fully mature pension. Is that right?
Kelsch was mature.
And Barron was mature. Is it mature here?
Oh, it is not mature because he's only had 17 years in on military side.
Number two, I think both of those cases included spouses who were forced to make direct payments to an ex-spouse.
Right.
That's not what was ordered here, right?
It was not, but they've also asked for direct payments on the FERS side when he gets to that normal retirement age.
Right,
so,
but we're talking about the rollover.
That's right, and you are correct. Barron is mature because it was at 20 years.
Okay, you only have 7 minutes left. Do you want to hit your other two issues?
I'm just going to briefly talk about the apportionment. We use the time rule, and it's never been approved or disapproved by the Arizona Supreme Court, but the trial courts in Arizona tend to think that the time rule is mandatory. It is not, and it's just not appropriate in this case, as I laid out in layman. What we're trying to do is, I think the equitable thing to do is to take the time accrued under military pay, which is frozen by law, just like we're freezing public safety, just et cetera, so it's nothing new, and we can take that lump and put it into FERS and even add COLAs. It's a lump sum. What they've asked to do is we get the time rule. So we'll take our percentage, we'll roll it into FERS, but it's going to grow because that's what the time rule does. And I think that's inappropriate. The reason is, as laid out in layman.
Explain to me, other than COLAs, how does it grow? I mean, if you have 17% of his, or pick a number, 50% of his time at 10 years, and you roll that over, it's still just that 5 years of window. So the percentage would get smaller as his total time
Yeah, it grows, and it's proven by the actuaries because the time rule captures the ending accrued benefit. So that coverture won't change, but the ending accrued benefit will change. So if he does another 20 years, that benefit is going to be significantly higher than it was if you froze it like it was in the military case. It does grow.
Yeah, because the value of the COLAs, et cetera, over time and his increased income, she gets a portion of that, but her percentage is still going to be just that 5 years out of the total 20.
Once again, that's correct. COLAs are minuscule. The growth isn't in the accrued benefit, and that's what the power of the time rule is.
You're right. COLAs is speaking inaccurately. The effect of inflation, the effect of increases in wages and time over increase of his earnings over the time is what I was using.
But that's not the factor. It's his advancement in the GS system in federal.
Right,
That's going to
his
yeah.
income.
It's not tied to inflation and all that. It's going to be his accrued benefit. That's the power of the time rule, because she would capture under their proposed time rule the ending accrued benefit. It's going to be significantly higher than it is if it was frozen at divorce. And what we're trying to do is bring that frozen military pay, because it is frozen, no survivor benefits either. There's no time is of the essence here. She has no survivor benefits. And we're just trying to plug that military into FERS, because it's not a modification of the military in FERS. As Lehman says, it's a new stream of income. It's new. She has no time under FERS, zero.
Well, if and I think counsel will elaborate on this, but if you use military time to buy benefit time under FERS, then don't you have a FERS benefit? So isn't it transmuted by the purchase of FERS time?
Yeah, I don't think it's transmuted. It's just moved over into FERS.
Okay, so now it's all FERS.
It is.
Okay, so then why aren't we playing by FERS rules?
Because she has no time in FERS, and that's where we use the time rule.
She used the military time to buy time in FERS.
She did. And it should be limited to actually what she purchased and what she accrued in the military system, not the FERS system. Okay. Thank you.
You have 3 minutes. Okay, you want to reserve for rebuttal?
Yes, sir.
Okay. Mr. Riley.
Good morning. May it please the court, I'm Daniel Riley on behalf of Vera Tolmachoff, and I have no relationship to any of the parties. So if I refer to Mr. Riley, I'm not speaking about myself in the third person. I'm speaking about Chad Riley. I confess to a certain level of frustration with this case. Throughout the case, it has often felt like we were wrestling with a shadow. Every time we thought we got a grasp on what it was that husband was arguing, he seemed to go in a different direction. And unfortunately, I'm still not clear after listening to the argument today. In his opening brief, he argues extensively that preemption applies, but then includes a sentence saying he's never argued that wife isn't entitled to FERS. That's what he just argued. And now today, he says that he's going to deposit his time, wife is entitled to his time. His gripe seems to be that he doesn't think wife should be allowed to tell him to deposit his time. So I'm not entirely sure why we're here.
Well, I understood counsel's argument to say it's a matter of timing, that at such time as husband decides to retire out of FERS, if he accrues FERS, then that would be the time then for rolling over, and that can't be compelled. That point of rollover can't be compelled. That's how I understand the argument.
And if he's basing that argument on the section of the statute that he read to you when he started his argument, let's read that again. This is section 1408 of Title 10, subparagraph C3. This section does not authorize any court to order a member to apply for retirement or retire at a particular time in order to effectuate any payment under this section. And the statute defines what a member is.
And I think we have a concession from counsel that the strict text of the statute does not admit of what he was ordered to do, but that's not kind of where we're at. So
how would you respond to his argument that I think he said Howe and Barron, the gloss of those sort of lean in his client's direction?
Those were cases that involved members and military retired pay. At the point that this case came to trial, Mr. Riley was not a member. He was not a member of the military, and he was not a person entitled to retired pay under the military. That's the definition. In
those cases, both cases?
Correct. In those cases, you had individuals who were either actively in the military or who were entitled to retired pay under the military. So they were classified as members under the statute.
Isn't rolling overtime kind of forcing the client or your opponent to receive a benefit under the military plan? I mean, I get that it's not squarely forcing him to retire, but it's asking him to move this time into another system.
So again, that provision of the statute is limited to members. And he was not a member when this case came to trial. He is not a member as we sit here today. And by his own admission, he's not eligible to ever become a member under the statute.
I asked him why he doesn't want to do this. Why does your client want to force him to do it now?
Because she wants to secure her interest in the benefit.
But if he got fired or quit the FERS tomorrow, presumably if we accept the statements of his counsel, he's not vested, she wouldn't get anything.
That's not accurate. No, if she is not vested, first of all, he's vested at the moment he has 5 years in service. And Judge Ferrua, you asked counsel, isn't he vested once he deposits his time? And the answer to that is yes. The expert who testified in this case, in his report, he talks about this. He says the moment that time gets deposited, he now has over 5 years in the system. He's now vested in the system.
Meaning the military time translates into time that counts against the vesting requirement.
Exactly. The expert explains that in the report.
Minute for minute.
I'm sorry, Your Honor?
Minute for minute.
Yes, Your Honor.
And so husband is now sitting on the immediate ability to be vested and is choosing not to be vested.
Correct, and that's what the expert also testified about at the trial. In addition to putting that in the written report. And I apologize, Judge Morris. You asked a question, and I think I got.
Well, the question is why does your client want to have it now when you? At least as far as we know, he's going to obviously want to roll this time over at some point. Why is she forcing the issue now?
Because she wants the security of having a court order that says she is entitled to a benefit.
Why couldn't the court just order that at some point before you quit FERS, you have to roll this over and do it?
Because of the judicial policy that says we want the finality of judgments. So what you are describing would be an order essentially saying, I'm reserving jurisdiction to enter an order.
No, I could say I'm ordering you to do it at some point before you quit work there. Just at the future, you were ordered to hereby do it. That would be a final judgment.
The judge could have done that,
yeah.
But that doesn't mean the judge couldn't have done what the judge did in this case.
You don't have any hesitation, and maybe that's an imprecise word, but with ordering him to come out of pocket now as opposed to 5 years from now or whenever it's more financially advantageous to him?
He doesn't have to come out of pocket. The judge said wife needs to pay for her portion.
Yeah, but he has to do the entire amount, meaning
he's
going to have to.
I know that's what Mr. Dietrich told you, but in the report that the expert provided, and Judge Furrow, which is your other question, is can't he incrementally deposit his time? And in the report, the expert says, absolutely. You don't have to deposit all your time at once. He could, if he chose, if he didn't have the money to add his own time, he could just deposit wife's time using the money that she was required to pay in order to add her time. So he does not have to come out of pocket. The expert also explained that he doesn't have to pay it as a lump sum. He can pay it through deductions from payroll. So if he didn't have the lump sum to add his time, he can pay that over time interest-free with deductions from his payroll.
I'm not as persuaded that there's a difference between requiring him to take $100 a month out of his paycheck versus borrow $10,000 to come up with his share of it in front. But did the court make a finding that he could do in this piecemeal? I know you said that there's testimony that he wouldn't have to roll his portion over at the same time. Or is there some kind of legal authority that we can rely on for that proposition?
I believe the expert cites the provision in his report. And the judge only ordered him to deposit wife's time. The judge did not order him to deposit all of his time into the system.
I have a quick question when you're done, I guess, looking.
Yes, Your Honor.
So let's say we affirm, and I'm not forecasting anything. Your client will then have full benefit of her share of the retirement benefits under her control. So why is it necessary to preserve the issue of Kolsch payments for the future?
I apologize. Could you say that again?
So it seemed to me there was some argument in yours about preserving the Kolsch issue. Is that accurate?
Yes. So in the
so if we affirm, then the question is why would that be? Why does that matter?
I don't know that it does matter.
Okay.
The law on this is the two key cases are going to be Quijada and Delin. And read together, what those cases say is you generally preserve the right to seek a Kelsch payment if it's unmatured at the time of the trial in the future, unless you've waived it. And wife didn't waive it here. So the quadro, technically it's called a court order acceptable for process when it's federal retirement, but I just use the general term. The quadro includes a clause that preserves her right to come back. In other words, she doesn't want to waive her right to come back. So the order preserves her right to come back, and it follows, Judge Morris, your plan that you laid out in your concurring opinion in Caswell, your practical guidance about what should be in an order if someone is preserving their right. The consequence that will give rise to it maturing, the way in which it will be calculated, and the way in which it will be paid. And those criteria are in that preservation clause.
So, Mr. Riley, just to put a finer point on what it is, at least for my mind, what you're saying is that the evidence is that husband can transfer only wife's time. And husband was ordered to transfer only wife's share of the military time. And wife was ordered to pay all the costs, the hard costs associated with transfer of only wife's time. And she tendered that payment.
Correct.
Is all of that correct? Is that an understanding?
Yes, those are correct. Now, the payment was rejected. She tendered a check, and counsel returned it, but she did tender the payment.
Right. And so there was both the ability and the authority to transfer only wife's time in the military system into FERS.
Correct.
And also you've clarified that transfer of wife's time, only wife's, would immediately vest FERS.
Correct, because it only requires 5 years to be vested, and her length of service is 5.7 years. So by adding her time, he would immediately become vested in the FERS system.
Okay.
And even if he wasn't vested, Judge Morris, to go back to a question you asked earlier, even if someone doesn't do all 5 years and they leave federal service, they don't receive nothing. They receive a refund of their contributions to the system. So there is a payment that would be at issue there. I wanted to address the formula issue. So husband takes issue with the pro rata formula that the court applied here to determine wife's interest in FERS. And he is requesting, if I understand him, sort of a hybrid military frozen benefit formula. The difference between FERS and military retirement is of serious consequence here. In military retirement, the former spouse's interest is frozen based on the years of service and rank and pay grade of the service member at the time of the divorce. But the former spouse does receive pre-retirement cost of living adjustments. FERS, there are no pre-retirement cost of living adjustments, and the retirement age is 62. So husband's formula, he wants to calculate what wife would have received or what had been accrued as of date of divorce in the military system, but then deny her 32 years of pre-retirement cost of living adjustments she would have otherwise received from the date of the divorce until his age 62 date of retirement eligibility that he'll have under FERS. And that's a significant amount of money. The expert testified.
But if he hadn't gone to work in a FERS eligible position, she would have nothing, right?
If he had left the military and had
Gone to
not
work for
gone
a
into,
private-
then yes, it would be a benefit, a worthless benefit.
But that would go both ways, right?
Correct. Neither person would receive anything, because military is what's called a cliff vesting system, meaning you are fully vested at 20 years, you are zero vested at any point prior to that 20-year mark.
So, on the formula, wasn't husband's number or his report excluded because he didn't produce it during the course of discovery?
Correct. So at trial, the objection was as to both foundation and lack of disclosure,
Okay.
and the trial court judge sustained it on the basis of non-disclosure.
And if husband isn't challenging that evidentiary ruling, what does this court do?
So we cited the restatement of, I forget which restatement we cited in our brief, but it stands for the proposition that if evidence is excluded by the trial court, then an appealing party may cite to it only insofar as they're challenging that ruling. Or
Did
excluding
they make
it.
an offer of proof?
No, there was no offer of proof made. Which is why we, in our answering brief, asked to strike the portion of husband's briefs, arguing his formula, describing his formula, because this was information that was excluded at trial, and he's not challenging that evidentiary ruling on appeal, and he made no offer of proof as to what that formula would be or how that math would work out. Wanted to also address the issue of attorney's fees in this case, unless your honors have other questions about the substance of the appeal. The statute we have cited as a basis for the fee award is ARS 25-324, which looks at two factors: the reasonableness of the parties and the financial resources. The husband's income is about 50% higher than wife's. Her income is $60,000, his is $90,000. So he has superior financial resources. The reasonableness, there are several issues I want to point out. One, Judge Weinsweg, what you just mentioned, citing on appeal information that was excluded at trial is improper. Should not have been done. The brief, respectfully, to Mr. Dietrich is perfunctory. The fact section, I think, was 1 page. It's confusing, contradictory. And it took a lot of time to try to figure out what it was he was arguing to then try to rebut that. We are asking that fees be imposed jointly and severally against both Mr. Riley and his counsel. And in considering whether to do that, this court can look at a variety of factors. It can look at people's conduct in other litigation. It can look at whether the briefs provided generally meet the standard that you would expect to see of an appellate attorney. And turning to that first issue, in the last 3 years, Mr. Dietrich has been counsel who has filed appeals in 8 different Quadro-related cases, has lost every single one, and in 5 of those cases, his clients have been sanctioned after this court found that the positions he advocated were not reasonable. This obviously is not deterring him. He continues to file these types of appeals in Quadro-related cases. And it's his clients that suffer the consequences of that conduct, and frankly, clients like mine who suffer the consequence because they have to pay the legal fees that are associated with the appeal. These are real people. This isn't family law. We just represent normal people. These aren't wealthy individuals who can afford these types of costs. They impose real costs on real people. And at some point...
So at what point should a lawyer stop making what they think is a good faith argument to change the law?
I don't know that there's a mathematical point, but if over half the time the court is finding that you're taking unreasonable positions, I compare that to my own career. I've been practicing since 2008, and I think clients of mine have been sanctioned twice in my entire career.
Mr. Riley, in light of this, because really what you're talking about, because the 25-324 is one thing, right? But really what you're talking about is imposition of what is a sanction.
Correct.
And in light of the Supreme Court's decision in Arizona Republican Party versus Richard, which says that lawyers should not be punished for long shot arguments, what are we to do with that?
There are long shot arguments, and there are frivolous arguments.
So your position is that this argument is absolutely 100% verifiably frivolous?
Yes, that is my position. The statute, we are not dealing with military retired pay. We are not dealing with a member, and yet he continuously argues that preemption applies, but then argues, well, maybe it doesn't, and maybe I'll deposit my time, and maybe she'll get some.
Rule 11 sanctions, or I don't even know if it's Rule 11 anymore. They keep changing the numbers.
I think it's 34 now.
Okay.
No, Your Honor, we did not request Rule 34 sanctions in the lower court. Any other questions from the bench? No. All right. Thank you, Your Honor.
Thank you, Mr. Riley. Mr. Dietrich, you have
Yes, sir.
about 4 minutes.
Thank you. Just a couple things. I think this use of member in 1408C3 is semantics, like the Howell court said about the decision of the Arizona court.
Which one of you is right about the partial deposit?
The incremental time.
Again, I don't want to misstate the procedure, but as far as I know, it has to be the entire amount, but they can work out payment plans, et cetera. What that rate is, I don't know.
I'm in the position now, one of you is lying to me. So his opposing counsel said that the expert testified and relied on authority that said your client could just deposit Weiss portion of the time.
I was just told, because I just confirmed that with my client, it has to be the entire amount, but he can work out payment plans. He can't come up with it as a lump sum. But as far as I know, and again, I don't want to misstate it, as I told earlier, the details of that I'm just not aware of.
Mr. Dietrich, there's an expert report in this record, and that expert report does it or does it not say that time can be transferred incrementally? That expert report.
Yeah, incrementally, and I agree with that. In other words, you can set up a schedule to have that deposit come over to FERS.
So what you're telling me is that what that expert report says is time has to be transferred all at once, 100%, and only the payments are incrementally. That's what you're telling me. The record says that report says that is the circumstance. Not time deposited incrementally. Incremental deposit incremental only applies to the payments. All or nothing transfer.
I believe that's
what the expert report says.
Okay, I believe that's true. Incrementally on the payments. So he can set up a payment plan or make the entire lump sum deposit.
I will review that report again.
Okay. I think that's all I have, Your Honor. Thank you.
We thank counsel for your arguments. We will take this matter under advisement and issue our decision in due course. The court stands in recess.